This channel does not promote any violence, harmful or illegal activities. All content provided by this channel is meant for educational purpose only.
We presume that you will be proceeding in the matter.
Lordship, please.
Now you tell us one. Today we may not finally hear you. Please release in the favor of the employees. This is what we had expressed the last time also. Yes. So 50% you release.
Well, may I?
We check up. There is no stay of the impugned order.
Your Lordship,
Only contempt.
So,
We will only stay here.
earlier,
What we propose to do.
yes.
Rather, you should volunteer. Generate goodwill for your employees. Pay 50%, subject to the outcome of the petition. And how to protect, assuming that you succeed, is something which you will have to tell us or we can ask.
They are in service employees. Exactly correct. But how will you given and the consequential directions can be given? Yes, yes.
No equities will be
All stages you have got.
One minute, sir.
I take it the question was put to me, not to my level. I have prepared a short note which I may hand over, which I would like to place for your Lordship's consideration before your Lordship passes any order with regard to 50%. Because I have two contentions.
Yes, Mr. Singh.
Well, I heard your lordships, Mother, I just heard your lordships. Can I make one suggestion? The amount,
Yes.
Mother, when you draw a very big line and then you one says 50%, it sounds reasonable. But your lordship will appreciate that the amount for the state is gigantic, it's humongous. It is some 40,000. I'll give you the exact figure, Mother. I'll just take a minute to give that. It's a very large amount. 50% of that will be backbreaking. Your lordship's three judgments hold the field. One, DA is not a vested right. Two, it is not a fundamental right. Mother, it will break the back. It will break the back of the state.
One minute, Mr. Singh. We have gone through your note. We have also gone through the judgments. There is someone else who joined. Mr. Singh, we have gone through your submission. We have also gone through the decision. Mr. Singh joined somewhere else. Mr. Singh joined somewhere else.
Yes, he joined in court simultaneously.
Doesn't matter, Mr. Singh. Don't worry.
Only present.
But he can't hear. Unmute करिएगा. Mr. Singh को unmute करिए.
Mother, I was putting my ear to the screen. That's all. I was not going anywhere.
That's all right. But what we see, we have gone through the judgments passed by the CAT, the judgment of the first round of the judgment, the second round of the judgment of the High Court, the order of the CAT, and the order. One minute, Mr. Singh, and the opinions of two honorable judges of the High Court. Now, what we propose to do is that two things that we will request you to come out with a figure 50% subject to the outcome or we pass an order.
Well, I understand. Your lordship may note 41,000 is the amount. I cannot give any answer to your lordship of that kind of amount for 50 will be besides 10%, brothers. Your lordship appreciates that. For a state, I can't speak like that. Number one. Number two.
These are your employees.
No, Malas, I can try and work out some solution, but I cannot promise anything to my lawyer.
What would be the consequence?
Number two, Malas, in the event, then your lordship, Malas, may give us an afternoon the miscellaneous speak. We'd rather argue it because it's a very huge financial backbreaking liability. In the miscellaneous speak, we'll do some Thursday or something.
We have gone through your notes. We have gone through the judgment.
But it will require some elaboration.
We are not inclined to even interfere. Let us be very clear.
I appreciate what my lord is saying, but this is not a matter of that time.
It is not a constitutional right. It is not a fundamental right. But nonetheless, because of your ROPA, the reason, kindly appreciate the single reason why this amount has become.
Exactly.
Mr. Singh,
Before ending.
Mr. Singh, we are very clear. Okay, we are passing an order. May you come please?
Well, your lordship may allow us to revert on Monday at least. Well, we haven't been No, we have not been heard, but then your lordship may consider this a very large amount. 50% is impossible. 20,000 crores.
We are scaling it down to 1/4 housing without 40%.
Put it on Monday, brothers. Then let us take some instructions.
Not be possible.
Can it possibly be increased?
And thank you very much. What are you saying?
Only one suggestion.
No suggestion. Please go contender. Mr. Just a minute.
All it. But as this one aspect.
We have heard him. But we heard.
Yes, the amount to be secure.
But as this one aspect.
These are employees in service.
Yes, but
But without remain.
Your
We can
lordship.
always
Forward are cancelled.
Your lordship.
And in this court, are you okay for the first?
I take it.
Speak when you spoken to, please. We are
Just one aspect that I wish to raise.
You are doing the same mistake which is.
No, look, I want to clarify one fact.
Mr. Retired employees. Please, Sanjay, Attorney.
Kindly pass the order which is put there.
Yes, please.
But my respectful submission is only this one. That we have no difficulty in paying as per ROP. There's no difficulty there. There are those two rubs in the impugn. The first is revise them twice a year. So we are submitting, so that is drawn from central government employees, which is not applicable to us. That's point number one. Point number two is revise it in the manner suggested by the tribunal. And there are certain findings which are returned by the tribunal, which say you will do it in this manner, which is virtually acting to central government. So those are the two laws. The third law, that under Rule 12, areas are not paid. So we are submitting that no areas should be marked on, because the areas that they are calculating is on the basis that you not equalize as per central government and you not revise prices.
What will you do, Mr.
Yes, so may I suggest now, this one thing, just on equity. What we are paying them today, as per our interpret rules, is 125% more from the time that the ROPA was applied in 2008. So, yesterday, my lords, a submission was made before your lordship that we are not paying DA at all. That's not factually correct. We are paying to the extent of 125% over and above the scale in 2000.
What we propose to get. Yet there's another thing also, whether they would be entitled to the same amount as is being paid to those who are posted outside the state. That's the third thing.
So the third aspect is now rendered again, because that part, Mullahs, has been struck down by the tribunal. And that part, Mullahs, we have discontinued. So that third aspect of being at par is something separate. So may I suggest
You 1/4 of the amount which is due, you disperse without any equity. And we fix the matter, yes, July, we post it in July for hearing.
Right.
I mean, the counsel to the parties.
But there's only one difficulty. I don't want to tomorrow be accused of not complying with your lordship's order. Because the impugned order says we'll have to work out the modalities. That's what the impugned order says. Saying evolve norms for the purposes of payment in this manner. What your lordship may do is, it shouldn't go as my statement because
We'll not put it in.
I make a statement. What I suggest that your lordship say 25%, but give us a little bit of time to evolve those norms, because that will require a lot of working out in terms of nitty-gritties of which says twice a year. But it shouldn't be twice a year, because twice a year.
No, we are not increasing it to that aspect. It's a lump sum amount which is coming out as per the order of the High Court. Strictly in terms of
There's no amount which has come.
when we follow in compliance.
We have heard Mr. Singh, sir.
Well, one sentence, your lordship dictates for us, one sentence. The highest slab of Mr. Patwalia's client's demand is based on twice a year. That's the main issue.
Correct.
Now, brothers, if Mr. Josefa has got some instructions, then brothers, 25% may be workable, but brothers, your lordship is hearing it. It may be a back-breaking thing for the state. Financially, a DA will break the back of the state. We are not running away anywhere. Lordship's final decree will be obeyed. So give a reasonable percentage. Kindly give a reasonable percentage.
And I want to make one suggestion. Let us take instructions over the weekend, just have it on.
Let me on Monday.
No, we'll come up with figures. We'll come up with figures early, so that there is no.
We made it clear, Mr. Singh, to you last week, and therefore we kept it. Having heard the concept of it.
Kindly be reasonable on the percentage.
So 25%, we agree with you, we are saying.
This is irrecoverable also, as your lordship knows.
Certainly,
Irrecoverable.
obviously.
Otherwise,
You have to consider
ready to go on with the final year in place, set out for final year.
would release at least 20% of our due and payable to the employees in terms of the impugned judgment or dated students, so master students, so in case of students. So needless to add, dispersal of such amount shall be without prejudice to the respective rights and contentions of the parties and subject to the outcome of the petition. List the petitioner. The respondents are permitted to place on record their submissions within a period of 4 weeks, or let's say parties. Because they have gone through the same way. Perhaps you will have to file revise. Perhaps. Parties are permitted to place on record their revised submissions. List the matter for hearing on that.
Within some 4 weeks, 8 weeks, 6 weeks.
No, the norms will have to be worked out. You want to answer the judge.
It's a time in terms of the High Court judgment.
We have said that they have the chat.
So great.
In treatment, we are not doing. No, treatment, we are not doing.
It doesn't matter at all.
Treatment, we are not doing.
I'm just excited that. He said that they will be heard. Perhaps so the people is already not there.
Maybe God will have to find you.
Treatment is like simply tag along.
That's right. In fact, on the earlier discussion, I understand my lord said we already heard the final.
Okay.
Item 62.
But gentlemen, one thing is there, we are telling you on this side. See, if Mr. Himati's contention that they are paying as per ROPA, then perhaps you will have an update us. No, we are telling you. But just listen to us. If anybody has to answer that in the first instance, why did he allow all disbursement twice in a year? And he course corrected midway and then gave only once in a year. That is something which you have to answer.
Yes, it's very well. There are only ICT norms.
No, we are just
That's fine.
That is advice for the lordship's observation. Because it is only 1 year that we paid for.
Yeah,
Otherwise, consistently we've been doing it.
And these are your employees, they must give you.
Ultimately, it depends on what the size of the person.
Right, Mr. MD,
Yeah.
let us say you candidly, we would have dismissed this petition. Why we did not dismiss it? Because we'll have all India ramification.
That's correct.
That's the only reason why we.
There are a couple of points for us. One is DA has been elevated at the level of a fundamental law. That's the basis on which the High Court.
It is next week.
Because I can't respond because I speak one line.
Yeah.
There are 5 sentences coming. Yeah.
For final hearing. Final hearing.
Would you also fix a date?
After date will be there. July, August will be. First August.
Yes, talking to the
But today orders will go now. Your vehicles.
Okay, share.
I'm great.
Thank you.
Item 62.